The Labour Protection Act B.E. 2541. The Labour Protection Act B.E. 2541 is summarized as follows. 1. Normal working time. Normal working day means the date the employee works. If there is any change about the first day at work, employer shall notify employee to ask for permission. If employee does not consent, employer will not allow to change because of the following conditions. 1. Normal working time shall not exceed 6 days a week. 2. Normal working time shall not exceed 8 hours a day, and for the work which may be harmful to safety and health of an employee shall not exceed 7 hours a day. 3. Employee is allowed to have weekly holiday more than 1 day per week. The day between each weekly holiday shall not be more than 6 days. Employee shall have traditional holidays more than 13 days per year, including National Labor Day. Employee who has worked more than 1 year shall have annual holidays more than 6 working days per year. 2. Wage and overtime wage. Wage refers to the money that employers and employees agree to pay for working under contract or a period of normal operation by the hour daily, weekly, monthly, or other period or pay by calculating employee work performance and includes the money that the employers pay to employee on a holiday and leave. Overtime wage refers to the money that employers pay employee to work overtime. Pay and overtime pay are summarized as follows. 1. The minimum wage rate shall be announced by the Ministry of Labor. 2. Overtime wage and holiday overtime wage. The remuneration of such exceeded hours shall be paid at a rate of not less than 1.5 times of the hourly wage rate or the piece rate of wages in a working day, and at a rate of not less than 3 times of the hourly wage rate or the piece rate of wages in a working day. 3. Employees, both male and female, have the right to be paid equally on wage, overtime wage, holiday wage, and holiday overtime wage for the same work, same quality, and same quantity. 3. Sick leave and maternity leave. Leave means the date the employee takes a sick leave, leave for sterilization, leave for necessary business, leave for military service, leave for training or development of employee's knowledge, or maternity leave. If the employee is taking leave, shall notify the employer, which may inform verbally, in writing, or verbal agreement. If employees stop working without giving a notice, it will be considered as an absent. 1. Wages shall be paid for sick leave as long as employee is actually sick, but shall not exceeding 30 working days per year. 2. Wages shall be paid for maternity leave not exceeding 90 days for each pregnancy, with 45 days wage. 3. Wages shall be paid for military service leave not exceeding 60 days with wage. 4. Wages shall be paid for sterilization leave for a period determined and a certificate issued by a first-class physician. 5. Wages shall be paid for necessary business leave, accordance with employee and employer agreement. 6. Wages shall be paid for training leave to increase the working efficiency. 4. Holiday. Holiday means the date that employee does not work, such as weekly holiday, traditional holidays, or annual holiday. 1. An employee is entitled to have at least 1 weekly holiday per week. Temporary employee will not be paid. 2. An employee is entitled to have at least 13 traditional holidays per year with pay. 3. An employee is entitled to have at least 6 annual holidays per year with pay, which is assigned by employer. 5. Severance pay. Severance pay means the money paid by an employer to an employee on termination of employment. It does not include other funds that an employer agreed to pay to an employee. 1. An employer shall pay severance pay to an employee whose employment is terminated as follows. 1.1. An employee who has worked for at least 120 continuous days, but for less than 1 year, shall be paid basic pay for 30 days at the most recent rate of basic pay. 1.2. An employee who has worked continuously for at least 1 year but less than 3 years shall be paid basic pay for 90 days at the most recent rate of basic pay. 1.3. An employee who has worked consecutively for 3 years but less than 6 years shall be paid basic pay for 180 days at the most recent rate of his basic pay. 1.4. An employee who has worked consecutively for at least 6 years but less than 10 years shall be paid basic pay for not less than 240 days at the most recent rate of his basic pay. 1.5. An employee who has worked for more than 10 years consecutively shall be paid basic pay for not less than 300 days at the most recent rate of his basic pay. 2. An employer relocates its place of business. An employer shall notify the employee of the relocation not less than 30 days prior to the date of relocation. If an employee does not wish to work for the employer at the new location, an employee has the right to terminate his employment contract and be entitled to special severance pay at the rate of no less than 50% of the rate of severance pay. 3. If an employer terminates an employee because of improvement to the working unit, production, distribution, or service processes arising from the utilization of machinery or a change of machinery or technology, if an employer fails to give advance notice to an employee of his termination, or give advance notice but shorter than 60 days, an employer shall pay severance pay to an employee as follows. 3.1. An employee will receive special severance pay in lieu of the advance notice in an amount equal to 60-day pay at the most recent rate of his basic pay. 3.2. An employee is entitled to get a severance pay. 3.3. An employee who has worked continuously for 6 years or more, the employer shall pay special severance pay in an amount of not less than the basic pay received for the most recent 15 days for each complete year of work. The total severance pay shall not exceed 360-day basic pay at the most recent rate. An employer is not required to pay severance pay to an employee whose employment has been terminated for any of the following reasons. 1. Dishonest performance of his duties or the intentional commission of a criminal act against the employer. 2. Intentionally causing loss to the employer. 3. Performance of gross negligence which results in severe loss to the employer. 4. Violation of the employer's work rules or regulations or order which are both lawful and equitable when the employer has already issued the employee with a prior written warning, except in a serious instance when the employer is not required to give a warning. The written warning should be effective for a period of 1 year as from the date of the commission of the violation by the employee. 5. Neglect of his duties for a period of 3 working days without reasonable cause, whether or not a holiday intervenes. 6. Imprisonment by reason of a final judgment. 6. Child labor. Employer shall not employ a child under 15 years of age, and if a child under the age of 18 years is employed, the employer should 1. Notify the labor inspector of the employment of the child employee within 15 days from the date when the child starts work. 2. Record the state of employment if there is a change from the original and keep it at the workplace or the employer's office and be ready to be inspected from a labor inspector at all time. 3. Notify the labor inspector of the termination of employment of a child employee within 7 days from the date when the child stops to be employed. 4. An employer shall arrange for a child employee to have a rest period each day of no less than 1 hour for the first 4 hours that the employee has worked. 5. An employer shall not allow a child employee under the age of 18 to work between 10 p.m. and 6 a.m., except where written permission has been granted by the Director General. 6. An employer may allow a child employee under the age of 18 to work who is an actor in the theatrical, drama, or other similar shows. An employee shall provide a child employee with a reasonable rest. 7. An employer is prohibited from causing a child employee aged under 18 to work overtime or on holidays. An employer is prohibited from causing a child employee aged under 18 to do any of the following work. 1. Smelting, blowing, casting, or rolling metal. 2. Stamping metal. 3. Work involving conditions of heat, cold, vibration, sound, and abnormal lighting, which may be dangerous as prescribed by ministerial regulations. 4. Work involving hazardous chemicals as prescribed by ministerial regulations. 5. Work involving poisonous microorganisms, which include virus, bacteria, fungus, or other microorganisms as prescribed by ministerial regulations. 6. Work involving toxic materials, explosives, or inflammable materials, except work in fuel oil service stations as prescribed by ministerial regulations. 7. Driving or controlling hoists or cranes as prescribed by ministerial regulations. 8. Work involving an electrically or mechanically operated saw. 9. Work which shall be performed underground, underwater, in a cavern, tunnel, or in a crater of a mountain. 10. Work involving radioactivity as prescribed by ministerial regulations. 11. Cleaning machinery or engines while the machinery or engine is in operation. 12. Work on scaffolding which is 10 meters above the ground. 13. Such other work as is prescribed by ministerial regulations. An employer is prohibited from causing a child employee aged under 18 to perform work in any of the following establishments. 1. Slaughterhouses. 2. Gambling houses. 3. Dancing halls, Thai or Malaysian-style dancing. 4. Establishments where food, liquor, tea, or other beverages are served, and where the services of prostitutes, sleeping facilities, or massage are offered. Other establishments are as prescribed by ministerial regulations. 7. Female labor. An employer is prohibited from allowing a female employee to perform any of the following work. 1. Mining or construction work which shall be performed underground, underwater, in a cave, a tunnel, or in a crater of a mountain, except where the conditions of work are not hazardous to the employee's health or body. 2. Work on scaffolding which is 10 meters or more above the ground. 3. Production or transportation of explosives or inflammable materials. 4. Such other work as is prescribed by ministerial regulations. An employer is prohibited from requiring a pregnant female employee to work between 10 p.m. and 6 a.m., or to work overtime, work on holidays, or perform any of following. 1. Work on plant or equipment that vibrates. 2. Operate or go along with a mechanically propelled vehicle. 3. Lift, carry, or bear on her head or shoulders, or pull or push loads that weigh more than 15 kilograms. 4. Work on water-going vessels. 5. Such other work as is prescribed by ministerial regulations.